Good evening, everyone. I welcome each one of you to our Advocate on Record Aspirants Academy. This is our 76th lecture series. We always recite the preamble of the Constitution of India before we go on to the topic. Because reason is preamble, the reflection of the entire Constitution provisions. The goal is enshrined in the preamble of the Constitution of India. So preamble, that is our unity and that is our dignity. Preamble reflects our commitment, sentiment. Preamble our goal, preamble our soul. Therefore, I request each one of you to recite preamble along with me, dear friends. We, the people of India, having solemnly resolved to constitute India into sovereign, socialist, secular, democratic republic, and to secure to all its citizens justice, social, economic, and political liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of the nation. In our Constituent Assembly, this 26th day of November 1949, do hereby adopt, enact, and give to ourselves this Constitution. Thank you so much, dear friends. We have gathered here to study about Article 370 of the Constitution of India, abrogation of Article 370. That is one of the landmark judgments for the AOR examination that falls under serial number 77 of the AOR leading cases. So before going on to the topic, we always believe that education without values, without virtues, is of no meaning at all. So we need to have virtues studied coupled with education that becomes a meaningful education. Otherwise, it becomes a mere degree. A sea water is there. People are thirsty. Whether can they drink the sea water? The answer is no. Water, water everywhere, and there is not even a drop to drink. Advocates are there with degrees. People are there with degrees. But are they doing it effectively? What is missing? We have asked Swami Vivekananda ji. We always invite many spiritual leaders and we ask them questions and they answer to our AOR aspirants. So what are the questions that we posed to Swami Vivekananda ji? I invite Swami Vivekananda ji and share his thoughts. The question that we have asked is, once we want to become an advocate on record, please tell us what are the qualities that we should imbibe to become an advocate on record. What are the qualities that we should imbibe for the effective preparation? Though we may be defective in nature, but how to remove the defects? How to become effective in the process of preparation of advocate on record examination? That is the question that we pose to Swami Vivekananda ji. Now, Swami Vivekananda ji is going to respond to your question. Swami Vivekananda ji says, everything begins with the thought process. That is very important, dear friends. So everything, our words, our actions, our conduct, everything originates through thought process. So mind, we should mind our mind. That is very important. So what is a thought process you should have? You should aim for securing gold medal in the AOR examination. That is the thought, or that is the aim that you have fixed in your mind. That must be very important. So once you have fixed the thought process that you want to be a gold medalist in the AOR examination, now what is next? Dream alone will help you in securing gold medal, because everybody wants to be the biggest person, the richest person, the topmost person. But are we in a position to achieve those greater heights? Are we giving such hard work to achieve those greater goals? The answer is no. So what is next is, the secret of success is, Lordship Swamiji reveals 3E, triple E. Education, education and education alone can help you to achieve those goals. And Swamiji has gone to foreign countries. There also he found poor people, but because of their education, they have changed their status. They have achieved greater heights. And Swamiji says that I have shed tears because my countrymen still starving in poverty, not able to analyze how to reach greater heights because they don't have education. So what is the difference between these people and our people is, education makes the difference. If you want me to give an example, Dr. B.R. Ambedkar, who was not even allowed to sit along with his classmates in the school, later on he was assigned with the work to draft the Constitution of India, the destination for our country, the destiny of our country. And he was the first law minister of our country. Why? Once they were considered untouchables, now given with the task to say that abolition of untouchability, right to equality, freedom of speech and expression. So he was the chairperson of the drafting committee. So what was the difference? The difference is education, education and education alone. Therefore, in order to uplift ourselves, we need to prepare our AOR examinations. That is 4 subjects. You should not see those 4 subjects as separate subjects, dear friends. You should see that it is all one subject, because all is related to the Supreme Court of India. Practice and procedure of Supreme Court, drafting petitions in Supreme Court, advocacy and professional ethics, what are the standards to be maintained by advocates practicing in the Supreme Court, leading cases pronounced by the Supreme Court. So Supreme Court is the goal, under which there are 4 subjects. So what you read in leading cases, you can correlate in practice and procedure also. You can correlate with drafting purpose also, as well as advocacy and professional ethics also. So the view has to be changed. So you should, when you are studying some important leading cases, how to apply it in professional ethics, how to apply it in Supreme Court practice and procedure, and what are the grounds stated in the landmark judgment, submissions made by the petitioner, submissions made by the respondents, although are those to be considered very effectively. Therefore, that can be written in the drafting paper. Very important, dear friends. So this is what the education is. Lordship Swamiji talks about this education. Apart from this education, what is required? Is it education alone is sufficient, or something else we require? The next aspect is devotion. Devotion. Lordship is talking about devotion. So dedicate your time exclusively for your AOR preparation, because everybody are practicing advocates, They need to earn their livelihood. That is important. Otherwise, landlord will lost rent after a month. So therefore, in order to satisfy everything, but still, advocate on record is a milestone in one's advocate's life. And that will not take you back. That will uplift you. That will take you to greater heights. If somebody wants to hand over the case to you, they will ask you the first question, are you an AOR? So once you become an AOR, you are respected by the clients. Clients will entrust you by handing over the brief, by which you can improve your lifestyle. So advocate on record is going to uplift you. Therefore, you need to have devotion. That is most important. After devotion, what should not be there with us is, we should not make fun of everything. Swamiji says that now the problem with India is ridiculing everything that is going through in the national blood. So be serious, be religious, have devotion. If somebody makes a prayer before Almighty, don't ridicule it. That is his freedom of religion. That is his faith. Everyone should be respected. Every religion should be respected, because all the religion takes to the one goal, that is Almighty. You may call water as Nilu in Telugu, Tanni in Tamil, water in English, Pani in Hindi, but refers to what? The same water. So you may call it in different names, but it refers to one person. What is that person? Respect everyone. It speaks in one language, that is love, affection, respect for humanity. That is most important. In those years itself, Lordship is cautioning everyone. This making fun of everything is not good. You should not do that. So after devotion, after sincerely studying towards the AOR examination, virtues, that is very important. Last but not the least, virtues means character building. We have to build up our character. In our character, it should help the poor people, the needy people, help our colleagues. Our AOR Aspirants Academy is one such kind. We have become already an AOR. We are having 10 years practice, but we want to help others, guide others at free service, but effective service. And it should be recorded and uploaded in YouTube. Therefore, anybody, they can watch and get benefit out of it. So virtues, education without virtues is meaningless, is useless. It is like a sea water which cannot be consumed by us. So therefore, dear friends, degree is not enough. Swamiji very beautifully says, when a person on one side, he has by heart all the books in the library. Another person who has not read any books but following only 5 principles in his life. So who is the greater person? The greatest person is one who is following those 5 principles in his life, is greater person than the person who has by heart the entire library. What is the use? What is the use by reading and reciting everything without imbibing and putting it in practice? So therefore, dear friends, you have to read your AOR examination, and you have to apply in your drafting. You have to apply in your daily routine, because advocate is always a gentleman. That is what Bar Council of India rule says. So this is the humble suggestions, advice from our Swami Vivekananda ji, and it is in your hands. You take it seriously. If you are serious, AOR examination will also consider you seriously. If you want to become gold medalist in AOR examination, respect it. The examination will respect you. So do your hard work with values. You will be definitely rewarded. Which law says? Law of nature says. Law of nature. And nobody can deny it. Nobody in this world can deny or go against the natural law. Once you are hardworking, once you are devoting your time, definitely the benefit will come to you. That is law of nature, and it cannot be challenged in any court of law. So thank you so much. We request Swamiji to be present here. Therefore, Lordship will listen to our 370 also, abrogation of. Thank you. Now, abrogation of Article 370, that is one of the leading cases. First, I will give you the brief background of the case, what has happened, the summary of the judgment, overview of the judgment. Let us understand. First is what happened in this case. Let us start from Indian Independence Act 1947. Let us all travel back to 1947. Mother India were under the clutches of the Britishers. They were ruling us more than 100 years. Now the issue is our leaders fought for India's independence. Britishers came out with an act called Indian Independence Act 1947, by which act they have said Britishers will cease to have control over India, number one. Now Britishers is out from this act, and power goes to whom? Power goes to the princely state rulers. So it comes to the rulers. And Indian Independence Act divides India into Dominion of India and Dominion of Pakistan. There were more than 200 princely states. They have given the option. Indian Independence Act has given an option to those princely states. You can be independent also. You can be with Dominion of India, or you can be with the Dominion of Pakistan. It is your choice. So likewise, some of the states joined Pakistan, princely states. Some of the states joined with India. And the credit goes to Sardar Vallabhbhai Patel ji. That is why he is called as Iron Man of India. He also belonged to our legal profession. So the Iron Man of India, Sardar Vallabhbhai Patel ji, made the unified India. What is the problem with Kashmir? Kashmir did not join India. Did it join Pakistan? The answer is no. It remained as an independent princely state. Who ruled? Who was the Maharaja of state of Jammu and Kashmir? Maharaja Hari Singh. He was a Hindu ruler ruling Kashmir as an independent country or a princely state. He is receiving a threat from Pakistan. So he is under the impression that Pakistan may attack us any time, and they may take away the entire place. They may occupy the Kashmir. So it is under threat. Maharaja approached India. Please help me. India said, yes, we will definitely help you. But enter into an agreement. Instrument of accession. IOA in short. Enter into agreement. We will help you out. So they entered into an agreement. Instrument of accession was signed. And thereafter, India protected Kashmir, and they became a part of India. But the notable point is they enjoyed the special status. Though they are part of India, whenever we read any of the acts, it says it applies throughout the territory of India except state of Jammu and Kashmir. Because reason is there is a particular article 370 of the Constitution of India, which provided a special status to state of Jammu and Kashmir. What is that special status? Special status is state of Jammu and Kashmir can have their own constitution. State of Jammu and Kashmir can have their own flag. In India, union list means it is the parliament has to enact a law. State list means it is a state can enact a law on those subject matters. But whereas the state of Jammu and Kashmir can enact a subject matter which are enumerated in both in the union list also, concurrent list also, except on foreign affairs, on defense and communications. So only with respect to certain conditions they were enacting law on their own. And there are some residential rights. A person, those who have right over the land, they enjoyed certain privileges and certain limitations also. So such special status are given to state of Jammu and Kashmir by virtue of Article 370. So this is the history, dear friends. Thereafter what happened? In the state of Jammu and Kashmir, Chief Minister resigns from the post because a party withdrew the support to the ruling party. Therefore, they did not have majority. So the Chief Minister was resigned from the post of Chief Minister. Thereafter, the governor of state of Jammu and Kashmir dissolved the legislative assembly. Number 2. First is resignation, so no government. Number 2, governor enters and dissolves the assembly. Number 2. Number 3, please see it, dear friends, one by one. One by one it happens, step by step. Once it is dissolved, the President of India is promulgating emergency under Article 356 of the Constitution of India, meaning thereby President takes control over the state. So emergency is imposed. After the emergency is imposed, 2 orders are passed. That is called constitutional orders, CO in short. Constitutional Order 272 and Constitutional Order 273. What does it say? Constitutional Order 272. 272 says the Constitution of India entirely applies to the state of Jammu and Kashmir. Before that, our Constitution of India did not apply to the state of Jammu and Kashmir in entirely. It was partially applied, certain provisions are not applied. But after Constitution Order, CO Order 272, the Constitution of India applies entirely to the Jammu and Kashmir state. That is 272. What is 273? CO 273 is abolition of Article 370 itself. The special status given to the state of Jammu and Kashmir was taken away, abrogated by the President by passing CO Order 273. Simultaneously, the Parliament enacted a law Jammu and Kashmir Reorganization Act, by which the state of Jammu and Kashmir bifurcated into two union territories. One is Jammu and Kashmir and Ladakh. So this is the historical background, dear friends, in short. Now what are the challenges? Challenges is by the petitioners. Number one challenge is that 272 passed by President, Constitutional Order 272 was challenged. 273, Constitutional Order 273 was challenged. That abrogation is wrong, it is unconstitutional. How it can be done? So they have challenged it. Bifurcation of union territory, bifurcation of state into two union territories, that was also challenged. So these were the challenges made by the petitioners before the Supreme Court of India under Article 32 of the Constitution of India. These are all the challenges. Now the issue comes up before the Honorable Supreme Court. The Honorable Supreme Court, what was the decision first? According to the Honorable Supreme Court, is this they have held, it was decided by 5 judges bench, therefore it is a constitution bench. Unanimous judgment. It is a unanimous judgment authored by my Lord Dr. D.Y. Chandrachud and 2 other judges, Honorable Justice, my Lord Justice Sanjay Kishan Kaul and my Lord Justice Sanjeev Khannaji, has given a concurring opinion but with separate views. So 5 judges, unanimous judgment. So what they have held, dear friends? Firstly, Constitution Order 272, by which the entire application of the Constitution of India to the state of Jammu and Kashmir is not bad, is not mala fide, meaning thereby they have said it is correct. Why they have said it is not mala fide? Reason is, according to the Honorable Supreme Court, that by saying that, see, Constitution should apply entirely, Constitution of India should apply entirely to the state of Jammu and Kashmir. How they have done it? By virtue of Constitution Order 272, by invoking the provision, Article 371D of the Constitution. But according to the Honorable Supreme Court, that is bad. That is not the provision. The provision is Article 370 Clause 3. So they could not have made the entire Constitution apply to state of Jammu and Kashmir through 371D. The approach is invocation could have been under Article 370 Clause 3. Though the invocation of the provision is bad, is incorrect, but still it is not mala fide exercise. Therefore, they have upheld it. Now, Constitution Order 273, which abolished the special privileges given to the state of Jammu and Kashmir, special status, that was correct, that was upheld, because Article 370 Clause 3, which says that President can do it, provided if it is advised by the Constituent Assembly. But Constituent Assembly was dissolved when the Constitution for Jammu and Kashmir was enacted. So there was no Constituent Assembly. So without the Constituent Assembly's advice, the President cannot act. Therefore, it was not acted at all for several years. But the Honorable Supreme Court, in their wisdom, they have held No, the president has the independent power. Even without the advice or even without the recommendation of the Constituent Assembly, they can act independently. So they have the enough power to abrogate Article 370 of the Constitution of India. So this was the one of the findings of the Honorable Supreme Court. Now the next challenge was bifurcation. But the learned Solicitor General submitted that though there was a bifurcation, but very soon we will restore the statehood. Therefore, that question did not gone into by the Honorable Supreme Court. So ultimately, 370 was abrogated and it was upheld by the Honorable Supreme Court of India. So this is the entire summary of the judgment, dear friends. Thank you so much for your patience hearing. Thank you.